Mr. President, thank you very much. I move private members' business item number 2938 standing in my name. Mr. President, thank you for your words. I've taken them on board, these ones today and the ones previously as well. On the 12th of January 1970, Cheryl Grimmer, aged just 3, went to Fairy Meadows Beach with her family. She was abducted, murdered and her body never found. Appallingly, her murderer, who now lives under the alias of confessed to the crime but has never faced the full consequences and justice for his actions. For 55 years, Cheryl's family and the community of the Illawarra have continued in their relentless, indomitable and inspirational quest for justice for this beautiful girl. I note and acknowledge the family and supporters of Cheryl Grimmer join us in the House today. I cannot put it better than in the words of the family themselves, and will read their open letter to the community and to this House. For more than 55 years, our family has lived with the consequences of Cheryl being taken from us, while the person who provided a detailed and corroborated confession to her murder has remained shielded from public scrutiny. Decade after decade, this case has been allowed to proceed without transparency. That reality is not only devastating for our family, it raises serious questions about public confidence in the justice system itself. Recently, we lodged four formal submissions with the New South Wales Director of Public Prosecutions, the New South Wales Attorney General, the New South Wales Premier and the UK Foreign Office. As part of these submissions, we have requested that the New South Wales DPP proceed with relaying of charges against or Mercury based on the evidence before them. We are not asking for special treatment, we are asking for the law to be applied as Parliament clearly and explicitly intended. Child protection legislation exists to protect children within the justice system, not to shield an adult accused of killing a child many decades after the murder. Why and how could someone confess to police in a sworn and signed statement in such graphic and correct detail to such horrific acts if they had not committed them? We believe serious errors of law led to the exclusion of critical evidence and the ongoing suppression of the accused identity. Those errors should be examined openly and they should be corrected. Cheryl deserves transparency, the community deserves transparency, justice demands transparency. I would also note, Mr. President, that the family, the community, and I would like to put on the record our thanks to former New South Wales police officers Damien Loon and Frank Sanvitali, whose reinvestigation into this cold case led to the astonishing rediscovery of the lost confession, the 2017 charges and the extradition of from Victoria to New South Wales, where he faced those charges. Mr. President, the transparency that the family demands involves us doing everything in our power to bring this murderer, known by the code name Mercury, to justice, to do everything in our power to resolve how it came to be that this detailed and explicit confession laid out here today in this notice of motion did not lead to the prosecution at the time, how the confession was ignored or even worse, potentially hidden for 40 years, and how it is that this and previous governments are not doing absolutely everything to diminish this nightmare for the Grimmer family and to bring this murderer who has lived free in the community 50 years doing who knows what to justice. Mr. President, I commend the motion to the House.
Thank you very much. The Honourable Tara Moriarty.
Thank you, Mr. President. I rise on behalf of the government in relation to this motion and in my capacity representing the Minister of Police, and I begin by extending my deepest sympathy to those affected by long-standing unresolved cases who continue to live with pain and uncertainty surrounding the fate of their loved ones, and I acknowledge the family in the gallery today. The government remains acutely aware of the profound impact these enduring cases have on families and friends. The government does, however, have an amendment to this motion. Mr. President, I move that the question be amended by 1, omitting the name of the person identified wherever occurring and instead inserting Mercury. 2, omitting paragraph 5 and instead inserting 5, that this House further notes A, the inquiry by Portfolio Committee Number 1, Premier and Finance into unsolved murder and long-term missing persons cases in New South Wales between 1965 and 2010, referred by this House on the 15th of October 2025. B, that the inquiry terms of reference include whether there existed impediments in the criminal justice system that impacted the delivery of justice to victims and their families, with reference to particular cases, including Cheryl Grimmer. C, that the committee is scheduled to hold hearings in May 2026 in Sydney and Newcastle, and is to report back to this House by the 30th of June 2026. We seek to move these amendments as the member has released the name of an individual subject to suppression order to replace the name of the individual subject to a suppression order to their pseudonym Mercury. Suppression orders are never made lightly. They depart from the fundamental principle of open justice that underpins our criminal justice system. But there are occasions where those same principles can impede rather than advance the administration of justice. Further, in light of the ongoing inquiry into unsolved murders and long-term missing persons, we seek to amend 5. Mr. President, the unsolved homicide team is highly experienced and skilled, a unit within the New South Wales Police Force comprised of experienced detectives dedicated to reviewing and progressing unresolved homicide matters. They conduct investigations with compassion and professionalism in pursuing justice and providing closure for the families and friends of victims. They never rest. Cases are never closed, and they will never stop until perpetrators are brought to justice. I also want to acknowledge the incredible work of the Missing Persons Registry, the MPR team, a team of highly skilled detectives that employ best practice investigative strategies, providing service and support to commands. I'm advised that due to their effort and skill, an average day for a missing or a missing person continues to fall from just over 6 days to 2018 to just approximately 23 days in 2025.
The Minister's time has expired, but she's welcome to seek an extension.
Briefly, if that's okay, I'd seek the leave. Not even
Is
30
leave
seconds.
Granted? Leave is granted.
Thank you. I can report to this House that the government is working collaboratively with the member on his unresolved murders and long-term missing persons cases inquiry, currently accepting submissions. The inquiry, due to report back to the House at the end of June, shines a light on the incredible work the Unsolved Homicides Unit and the Missing Persons Registry do. I understand the difficulties here, but the support of the government for this motion is subject to the acceptance of our amendment.
Thank you. The Leader of the Opposition.
Thank you, Mr. President. Mr. President, I also join with the government in extending my deep-felt empathy with the position of the Grimmer family in relation to this unsolved murder, and in many respects, in their mind, it must be a matter which should be solved, but for circumstances which have arisen by virtue of a decision of the Supreme Court, and I will address that. The motion correctly notes that in 2019 the Supreme Court ruled in R versus Mercury that a record of interview conducted by police in 1971 with a minor was inadmissible in evidence. The motion then proceeds not only to recite the entire content of this inadmissible record of interview, but to name the person interviewed. The member does this despite the Supreme Court stating in the decision that Section 15 A of the Children Criminal Proceeding Act 1987 NSW New South Wales requires that the accused not be identified, and so he is referred to the case title by the pseudonym Mercury. Unfortunately, the Honourable Jeremy Buckingham has chosen to use parliamentary privilege to flout this ruling of the court, and has publicly expressed the goal of making the name of the person interviewed more widely known through Google processing this debate. The opposition believes in the separation of powers. We, the legislature, make the law, the courts apply it. The opposition also backs the police to do their job without this House passing gratuitous motions calling on them to do so. if, of course, the amendment the amendment of the government is passed, we will be supporting that amendment.
Thank you. The Honourable Rod Roberts.
To make a contribution to this particular motion and say I'm cognizant of the fact that the family and supporters of Cheryl Grimmer and the family are here today, and I understand the significant adverse impacts of the family and acknowledge the pain and suffering of them, and no one knows that probably more than me, bearing in mind that I spent nearly a third of my life investigating major crimes, and last Saturday's Telegraph in the Mark Murray column highlighted in particular two investigations I led, one being a kidnapping and sexual assault of a young 14-year-old girl that took us 5 days to find her, fortunately found alive. So I bring great experience to this, but I have concerns, Mr. President, and my concerns are this. And if I turn to the actual motion itself, and that is at 2, and then we go down to K, L and M. Well, I'm not going to mention his name. The accused objected to the admissibility of the typewritten and signed record of interview on the 29th of April 71. The Crown accepted its case could not succeed without it, and M, Judge Hume ruled the record of interview admissible. What we're missing is N and O. He ruled it inadmissible. What happened after that? Was he discharged? Was he acquitted? Because what the member may not be aware of, and he's very well intentioned here, and I understand that and want to acknowledge that, and that is the doctrine of autrefois. I'm looking at Mr. Murphy, he would have an understanding of that. Mr. Lawrence would have an understanding of that. Mr. Tudhope would have an understanding of that. The doctrine of autrefois is that if somebody is acquitted, or convicted for that matter, there is no double jeopardy. You cannot go back and have a second bite of the cherry. And members that have been in this chamber for some time will remember that in 2019, Mr. Shoebridge presented a bill to this Parliament called the Crimes Appeal and Review Amendment Double Jeopardy Bill 2019, of which the Law and Justice Committee, of which the Honourable Greg Donnelly is on, and I investigated the possibility of changing legislation to allow for double jeopardy. In the end, we said no. I want to quote from part of the submission from the Law Society of New South Wales to that inquiry. The High Court of Australia reiterated the foundations of the rule against double jeopardy in the Queen and Carroll 2002 High Court of Australia 55. It is a fundamental rule of law that no man is to be brought into the jeopardy of his life more than once for the same offence. Policy considerations for the rule against double jeopardy go to the heart of the administration of justice and the retention of public confidence in the justice system. The main rationale for the rule is that it protects against unwarranted harassment of the accused by multiple prosecutions. Judicial considerations need to be final, binding and conclusive if the determinations of the court are to retain public confidence.
The member's time has expired, but he's welcome to see
May I seek a very short
2-minute extension?
Yeah, 2 is fine.
Is leave granted? Leave is granted.
And finality in litigation, it is critical and basic principle of adversarial justice. I don't put myself any better than any member in this chamber, but my life, over 20 years of my life, was dedicated to locking up grubs like this particular person. To see this happen is a travesty, but there are rules in place. I used to lecture at the detectives training course on autrefois. That's why sometimes investigations take forever, because you only get one bite at the cherry, Mr. President. And as unfortunate as that may be, I feel as though that's the position we may find ourselves in here. And that's the difficulty with this motion that appears before the House.
Thank you very much. Are there any further contributions? Ms. Sue Higginson.
Thank you, Mr. President. I rise on behalf of the Greens to make a short contribution, and I too acknowledge the family here in the chamber today, and I thank them for their strong advocacy, because justice for Cheryl Grimmer is justice for all victims who have not yet had justice. And we know that our criminal justice system has failed many people, but this case is one that came to my attention when the amazing Lucy Small, who used to work in my office, first came in contact with some of the family members, and when we went through the historic accounts and spoke with members of the family and associated people, it was heartbreaking for anyone. We do support the member's motion. I acknowledge the comments of the former speaker. I think that he has got some very sobering, real observations that he's made here today in relation to the laws around double jeopardy. But I don't think that that should stop the resources and the investigation and the continuation of the path to justice. Justice can come in many, many ways, and I think the greatest injustice of all is when the pathway is left and there is no one on the pathway other than the real victims of the state, and not pursuing justice and not walking down that pathway is the greatest injustice. So on the basis of all the facts and circumstances, and in particular the work of the family and the commitment of the family to keep on going, we support the member's motion. I do indicate that we will be supporting the government's amendments to the motion. I think that they are really sensible amendments, but I also know that they're amendments that will be made, but also the member and the family will still be able to achieve the purpose that bringing the motion to this House has ultimately achieved.
Thank you. Are there any further contributions to the amendment? The Honourable Jeremy Buckingham.
Yeah. Thank you, Mr. President. I appreciate the contributions of all members, but
My apologies, Mr. Buckingham. I've just been advised you can only make these comments in your reply since you've moved the motion.
All right, okay.
I suspect there may not be any other contributions, but I will check. Is anyone else seeking the call? All right. The Honourable Jeremy Buckingham in reply.
Thank you, Mr. President. I appreciate the contributions of all members and certainly appreciate their empathy for the Grimmer family and, of course, this terrible issue that we are faced with, the complex area of law, no doubt. And I will not be opposing the amendment. Noting the government and the opposition's position of not wanting to name Cheryl Grimmer's murderer, I would like to take this opportunity to say directly to Mercury, to and now, you are a coward, a slug and a murderer, and you should do the right thing now and hand yourself in, explain how it was you made that confession in 1971, admit to your egregious crime. You have not gotten away with anything. Also, in reply, I would note the work of the Grimmer family, especially Dr. Michael Grimmer, who have recently made 4 submissions lodged with the following authorities. As I've said, the New South Wales DPP, Attorney General, New South Premier, and also the UK Foreign, Commonwealth and Development Office. These submissions outline the relevant evidentiary material, research findings and supporting analysis prepared in relation to this matter. They also outline the errors of law that they believe appeal that are part of the judge's decision. The court's decision immediately looked wrong. Firstly, police followed the rules when they interviewed Mercury. Secondly, the attributes of the accused that the court relied on to exclude the confession, such as conduct disorder, are exactly what you would expect in a juvenile murderer. Thirdly, the court failed to consider the victim and the community. The submissions highlight this, and the submissions highlight that the Supreme Court in 2019 was required by New South Wales law to refer to documentary evidence to guide interpretation of key legislation, but it failed to do so. So the family maintains there's been a failure in policing historically and in the application of the law. The core of the family submission is that the DPP relay charges, noting that the complex issues around double jeopardy against and proceed to trial. Mr. President, I and the family, the people of New South Wales, urge the government and the New South Wales Police, the New South Wales DPP to act in this case and find a way to relay charges. We ask the New South Wales Parliament to do the right thing and support the unmasking and prosecution of the murderer. I commend the motion to the House.
Thank you. The Honourable Jeremy Buckingham has moved private members' business item number 2938, to which the Honourable Tara Moriarty has moved an amendment. We'll consider the amendment first. The question is whether the amendment of the Honourable Tara Moriarty be agreed to. All those of that opinion, please say aye. Aye. To the contrary, no. I think the ayes have it. The ayes have it. We'll now consider the substantive motion as amended. The question is that the motion of the Honourable Jeremy Buckingham as amended be agreed to. All those of that opinion, please say aye. To the contrary, no. I think the ayes have it. The ayes have it.